Good afternoon and welcome to another webinar of the America-Europe Chair on Technology, Innovation and International Regulation. My name is Joana Gomes Beirão and I'll be moderating today's webinar. Before we begin, just a few words about the chair. The America-Europe Chair on Technology, Innovation and International Regulation is an interdisciplinary initiative of the America-Europe Fund, which aims to bring together expertise at KU Leuven in order to track, examine, and compare regulatory developments relating to technology and innovation in America and in Europe. And on top of that, the chair also promotes opportunities for cooperation and learning between policymakers, business communities, civil society actors, and knowledge institutes from both sides of the Atlantic. Today, we are fortunate to have Niels van de Zand and John Bender for an interesting discussion on how the European Union and the United States are approaching the regulation of blockchain and cryptocurrency. The timing of this webinar is actually quite perfect because it was precisely today that the markets in crypto assets regulation was formally adopted by the Council of the European Union. And on the other side of the Atlantic, there have also been some interesting developments in recent times as several governmental agencies and US states have been actively addressing regulatory concerns over digital assets. Our first speaker, John Bender, will share with us his expert insights on how the US is regulating blockchain and cryptocurrency. John is an attorney based in Seattle with extensive expertise in blockchain and cryptocurrency, including representing crypto and fintech companies in the US. He serves as a lead counsel in a number of legal cases at the intersection of blockchain and US securities law. Our second speaker, Niels van de Zand, will present and share his expert views on the EU approach to regulating blockchain and cryptocurrency, including the markets in crypto assets regulation. Niels is a legal consultant at Timelex, specializing in fintech and IT law, and he's also a research fellow at KU Leuven's Center for IT and IP Law, where he successfully defended his PhD thesis entitled Regulating Virtual Currencies, a Legal Assessment of Digital Representations of Value Under Financial and Economic Law. I will give the floor first to John and then to Niels, and then we will end our webinar with a discussion and Q&A. Now I'd like to warmly thank our speakers and our audience for joining us today, and I'll pass it over to John for his presentation.
Thank you so much for the warm welcome, Joanna, and good morning or evening to everyone who has tuned in. I'm going to share a few slides. I'd like to express my appreciation to the Center for Global Governance Studies and the America-Europe Fund for inviting me here to speak. I'm speaking to you today from my offices in the Financial District in downtown Seattle. My offices are located actually in the old Federal Reserve Building on 2nd Avenue. This building still has the stainless steel bank vault that the federal government installed in the basement when the building was constructed in 1950. And of course, for decades after the building was finished, the vault contained, one can imagine, large volumes of fiat currency belonging to the federal government of the United States. And if anyone makes it out this way, which I encourage you all to do, you can visit my building and stand inside this now retired, massive but empty bank vault, which I like to think is a small illustration of the impacts of technology and progress on our society today. It is no secret that the Washington State and the West Coast of the US more broadly has been a hub for innovative technology companies for many years. Companies that have made a fortune challenging the status quo and changing how the computer can be used to improve society the world over. My office is only a few miles from the storied campus of Microsoft and just a few blocks from Amazon's famous downtown campus. I don't have enough time to list all of them, but the companies we think of today when we think of successful technology companies in the US, regardless of where they base their headquarters, have all by and large benefited a great deal from a highly favorable regulatory environment in the US over the past 3 or 4 decades. These companies, Microsoft, Amazon, Google, Apple, you name it, have literally changed the way you and I interact with the world on a daily basis. And I, for one, am old enough to remember Web 1.0, as they call it, or the days of the landline internet. Some of you may not be old enough to remember, but it used to be the case, at least in the US anyway, that if an ordinary consumer wanted to get on the internet, they would have to connect to the internet using your own home's landline or home telephone. And it used to be that typically, by and large, households only had one landline. So if your father, brother, or mother, or anyone else wanted to connect to the internet at your house, anyone that might be calling you could not get through to reach you. And I remember as a teenager, that was, always very frustrating. This was, of course, before the time everyone had powerful cell phones and wireless internet in every building, many years before the iPhone. And I sometimes think of this and how much things have changed and chuckle to myself. I will dispense with the history lesson, but to be sure, technology has obviously dramatically changed the way we interact with the world over. As for the present day, I believe it is safe to say that blockchain and decentralized ledger technology will play a significant role in the progress and innovation we will see over the next few decades. We are entering what has been branded Web 3.0, a phase characterized by technologies that will reduce the importance of institutional gatekeepers in favor of automated consensus mechanisms to facilitate everything from online engagement to the exchange of goods and services. That being said, how these applications are regulated and supported at the state level, national level, and even internationally will play a significant role, obviously, in determining how long it will be until society can benefit from these technologies and reap the full benefits. As we all know, regulation drives outcomes in any new industry. What has made the US a hotspot, and it's not unique in this regard, but a hotspot for innovative technology companies is a question far too complicated to address here today, but it should be no secret that one of the key ingredients has been the fact that the US has benefited from predictable and more or less transparent regulatory frameworks that have enabled companies with serious ideas to plan their compliance ahead of time and also conduct business. For example, this may come as a shock, but my 3-year-old daughter is a big fan of ice cream. So let's imagine when she grows up one day, she develops a new ice cream concept that she wants to turn into a successful business. At least in the US, her new company and its advisors will know pretty much immediately that there will be state and federal rules applicable to the manufacture and distribution of food products that her company will need to comply with if they want to stay open for very long. In addition, these rules, although they change from time to time, are relatively stable. They've been interpreted, they've been applied for decades. People know what they mean and how they apply. And when they do change, there is a formal procedure and comment process that agencies like the US Food and Drug Administration must adhere to so that the public, manufacturers, merchants are informed and can continue operating. Historically, by and large, this has been the case in the US, whether you're manufacturing ice cream, opening a bank, a real estate brokerage, or raising capital through private or public investment offerings. Every so often, though, technology and innovation can challenge and force us to re-examine our incumbent regulatory frameworks. Technology can pose novel questions about how the application of that technology should be regulated. I'd argue that this re-examination process is essential because states and unions risk driving away economic growth to competitors by failing to upgrade their regulatory approach with technology. In my view, the goal should be to strike the right balance between two competing priorities of regulation: fostering innovation while penalizing misconduct. And achieving this is a task for both legislatures and regulators alike. I would argue that regulators, i.e. the public servants and their agencies tasked with implementing the laws already on the books, have a role to play that can be just as important and impactful as the people who make and pass the laws. Needless to say, actually finding the right balance or something close to it is always easier said than done. It can be messy and characterized by trial and error. It is often a process that takes time to play out. And that is what is happening in the United States right now when it comes to the raging cryptocurrency debate. Now, the debate in the US is being waged on multiple fronts and in many different industries. Today, I'm going to focus part of my discussion on the interplay between cryptocurrency and US securities law and regulation at the federal level. And then I'm going to turn my attention to some of the things that are being done at the state level. The debate over whether digital assets are securities and thus can be regulated by the Securities and Exchange Commission is currently raging in the United States. The news coverage is amped up on a daily basis. And the reason for that is that the stakes are extraordinarily high when it comes to the application of US securities laws to digital assets. Over the past 5 or more years, crypto assets or digital assets have proven to be a very effective way to raise a significant amount of capital at a fraction of the cost in a fraction of the time as compared to traditional private or public securities offerings. Now, raising capital is not the only application for digital assets. There are many when we are learning about new applications all the time. But the truth is, as it turns out, digital assets are a highly effective and efficient way to do so on a large scale in a very short period of time. And let's just say the poor business practices of some companies operating in this space over the past 5 years has, rightfully so, garnered the full attention of regulators around the world, including the US Securities and Exchange Commission. So how have lawmakers and regulators responded to the rapid growth and popularity of the quote unquote crypto industry in the US? In general, there is no uniform consensus in the US right now at any level of state or federal government about how best to regulate crypto assets, with maybe one exception, and that would be the state of Wyoming, and I'll talk a little bit about that in a little bit. But overall, there is no uniform consensus across the board, and I don't see one forming anytime soon. The SEC, especially under current leadership, has taken a broad view of its jurisdiction when it comes to crypto assets. The linchpin of the SEC's jurisdiction in general is whether a particular crypto asset qualifies as a security under the Securities Act of 1933 and the Securities and Exchange Act of 1934. To date, the SEC has not engaged in traditional notice and comment rulemaking with respect to promulgating any hard and fast rules governing what does and does not qualify as a security. This has been a major basis of criticism of the SEC so far in the US, The industry asserts the SEC is doing more harm than good by spending its time bringing enforcement actions rather than engaging with the industry and the public about creating a legal framework with predictability and hard and fast rules. Coinbase and others have petitioned the SEC to initiate a formal rulemaking, and that process is playing out in the courts right now. Instead, today, the SEC has done really two things. In 2019, it released a framework for investment contract analysis of digital assets. I don't have time to give this document full justice here, but to say that it is an official expression of the SEC's current view that many digital assets can qualify as securities under what is known as the investment contract test that was developed by the courts nearly 80 years ago for purpose of US securities laws. I'll talk a little bit about that in a second. More recently, the SEC has ramped up enforcement actions against the industry, both in terms of actions against exchanges and other platforms, and even individuals asserting that they're dealing in unregistered securities and similar allegations. So I mentioned the investment contract test under US securities laws. I'm not going to belabor this point, but just to say that the US Supreme Court defined what an investment contract was in 1944 in the quote unquote Howey case. The Howey case has garnered new popularity in the US in all circles, it seems like. A couple things to know about this case. The test is designed to be very flexible and fact specific. SCOTUS, in essence, left it to the SEC and the courts to be the ultimate adjudicators on a case-by-case basis. And fully understanding why the Supreme Court defined a security this way requires understanding the broader history of the two Securities Acts I mentioned before that were passed in 1933 and 1934. In brief, these laws emerged out of the aftermath of the 1929 stock market crash and the Great Depression in the 1930s. They were designed to regulate and prevent the practices that the US Congress found had contributed to the economic disaster that they were dealing with. And a main purpose of them was to adopt a policy of full disclosure with respect to securities transactions. Now, over the years, the Supreme Court has clarified and applied its Howey test to different transactions and instruments. And if anyone's interested in a list of these cases, just email me after and I'd be happy to send them to you. So it is this issue, whether digital assets are securities under the investment contract test, which is currently being litigated in several high-profile cases in the US right now. These cases include SEC v. Ripple Labs, SEC v. Wahi, and SEC v. Bittrex. Again, if you want to email me afterwards, I'm happy to provide you with more information. Now I'm turning to President Biden's March 2022 executive order. Again, a full dive into the executive order is beyond the scope of this presentation, but here's my high-level overview. It did not adopt or implement any legal or regulatory change. It calls for the development and adoption of policies that support US competitiveness and innovation, as well as rooting out abuse and criminal enterprise. It established an interagency process for departments within the executive branch to coordinate on developing policies. And at bottom, it is a positive thing because it reflects the fact that digital assets and their benefits and risks have the administration's attention. Obviously, we are still waiting to see the details of policies that emerge from this process. It's far too early to prognosticate about what we will see. I'm now going to quickly cover what is happening at the state level. Specifically, first, New York was one of the first states to adopt regulations addressing digital assets. You may have heard about the quote unquote BIT license, which is a regulatory framework that New York adopted in 2015. It covers and applies regulations typically seen in the financial industry and the banks, such as due diligence and custody requirements to virtual currency businesses broadly. Unsurprisingly, when it was adopted, it was the subject of criticism, including by Kraken, who famously said that they were leaving New York for greener pastures, so to speak. Wyoming adopted an approach that was quite different than New York between 2018 and 19. Wyoming famously passed and implemented 13 new state laws favoring the digital asset industry. These laws were passed as part of a deliberate strategy to attract crypto industry to the state. Wyoming exempted digital assets companies from Wyoming's money transmitter law. Wyoming created exemptions to state securities laws, specifically an open blockchain token. It created a Financial Technology Sandbox Act that gives companies with innovative financial products or services who qualify exemptions from certain state laws. It also created a special depository institution for crypto companies that basically allow them to get state charter and function as a bank. Finally, in contrast to Wyoming, my home state of Washington amended its money transmission law to expressly include digital asset companies. That's significant because that means if you're engaged in the transmission or deposit or creation of crypto tokens, you need a license, and it is a very burdensome process. Washington's Department of Financial Institutions has also been active in enforcing state securities laws like the SEC on the national level. But on the positive front, Washington's legislature created recently a work group with lawmakers and industry leaders to develop policy recommendations for the state legislature. I only have a few more seconds left, but with that, I just like to say the question of what is good regulation is a very tricky one. Like I said, it's a messy process. It typically requires trial and error, but I think that it rests somewhere on the spectrum between the competing priorities I mentioned earlier. That would be fostering innovation while also penalizing misconduct. Thank you for your time.
Thank you very much, John. Before I give the floor to Niels, I'd just like to let our audience know that they can ask questions for our speakers using the Q&A tool, which you can find at the bottom of the screen. And we will go through these questions at the end of the webinar. For now, I'd like to thank Niels for joining us today. And you have the floor, Niels, for your presentation.
Okay, thank you, Johan, for the invitation, of course, and thank you all for being here. So I'll briefly talk today about the EU blockchain strategy on the one hand, and then, of course, a new framework that was just today approved by the Council, the Markets in Crypto Assets Regulation. So let's start with the EU blockchain strategy. So it's really a policy goal of the EU to become an innovator in blockchain and to become a leader in development of blockchain technology and applications, rather than having to rely on what's being developed elsewhere. But of course, EU developed blockchain tools and technologies need to comply with a couple of core EU principles. Data protection, first of all, we have very strict data protection laws with the GDPR. So any development in this field would have to comply with that as well. Environmental sustainability is another point, because as you all know, there is quite a bit of concern about the sustainability of certain blockchain applications, like for instance, Bitcoin, which has very high energy use. Digital identity and cybersecurity are a couple of more policy goals being set forth by the EU. that you also see in other instruments like the new Network and Information Security Directive, which was adopted late last year, and the new European Digital Identity Framework that is being developed right now. And of course, interoperability is a major issue there as well. Now, how does the EU want to accomplish this? There are a couple of core elements here. First, the EU has developed what's called EPSI, the European Blockchain Services Infrastructure. So it is a general blockchain infrastructure, just a basic layer for the EU public sector that they can use for all kinds of applications like issuing digital identities, issuing diplomas, etc. So public sector entities can latch on to that, use that as their core building block for what they want to develop. So that's good to have something like that at the European-wide level. In terms of funding, there is, of course, a Rise in Europe program by the European Commission and also a separate fund for blockchain and AI investment. So the idea there is to really finance all kinds of developments in this sphere. Regulatory sandboxes are being developed as well that will allow developers to try out certain things under the guidance, of course, of regulators, but without having to comply with the full scope of the legal framework immediately. In terms of legal certainty, if you want to use all kinds of tokenization products and smart contracts, and obviously they will also need to have a certain legal value. You will need to recognize the value of smart contracts. And all of that is also being developed in European legal frameworks right now, such as the Digital Identity Framework that I referenced a moment ago. And also here, in terms of standardization, there is a lot of cooperation at the European level, but also internationally, like within ISO. So moving on to the legal framework then. If we look at the situation before this year, there wasn't really any regulation that was very specific to crypto. The only regulation that we really had was the fifth anti-money laundering directive that was adopted in 2018. And that one gives a definition of virtual currencies. And you can see the definition here. It's a very broad definition. It could span all kinds of things, including cryptocurrencies, but it could also be considered broader than that. However, in terms of obliged entities, AMLD5 only refers to two types of service providers, namely crypto exchange services and custodian wallet providers. So when you use these two service providers, they will fall under the scope of this legal framework. What does that mean? Well, if you're a crypto exchange service provider or a custodian wallet provider, you will need to register with the local authority. And this is really on a national basis. If you want to be a crypto exchange that's active all over Europe, you will probably need to register in almost every member state, which is a very cumbersome and expensive process. In practice, it's very hard to accomplish that. And then, of course, they will need to apply anti-money laundering rules, including know your customer obligations. So that's where we are today, and where are we going in the future? Well, with the markets in crypto assets regulation that was voted in the European Parliament a couple of weeks ago and agreed by the Council, this will be published in the official journal very soon and it will become applicable next year. So this addresses two things. First, the issuance offered to the public or admission to trading of crypto assets. And second, providing services related to crypto assets. But the idea is that this is more of a residuary framework, if you will. There are certain types of crypto assets that may already be regulated under other frameworks, and I will later come back to, for instance, security tokens. They will continue to be regulated there. But, however, the vast majority of crypto assets that did not fall under any other framework was until today unregulated, and that's where MiCAR aims to apply. So this is really trying to address that big gap that we still had in the field of regulation. Now, if you then look at crypto assets, MiCAR actually identifies three types of crypto assets. First, there is crypto assets in general, which are just digital representations of value that can be transferred and stored using blockchain or similar technologies. It's of course a very broad definition. It's also trying to be a bit future-proof, of course, because it's a field that's developing very rapidly. And second order, you have the asset reference tokens. These are tokens that try to have a stable value by referring to another value, which could be one or more official currencies, it could be commodities, could be anything. So these can include stable coins, also algorithmic stable coins, but it's still a bit of a broad field. A little bit more narrow then, you have the e-money tokens. Those are the crypto assets that only refer to one specific official currency, like for instance USDC. So these are really the true stable coins, if you will. So those are the three types of crypto assets that will be regulated under this framework. And then next to that, of course, you have the services. It's quite a lengthy list here. A couple of these services are, of course, quite specific to crypto assets, like providing custody, exchanging crypto assets for funds or other crypto assets. But the other ones, like operating trading platforms, placing, reception and transmission of orders, these are all types of services that we can already see in the existing MiFID framework, which regulates investment services. So you see that kind of logic quite a lot in MiCA. It's saying, okay, we have this framework for traditional investment products and traditional investment services, and that's working really well. So let's just take what's working there and apply it here. So it's really that kind of logic that you can find in this framework. Now going a bit into what it will all mean in practice, for the sake of time, I can't really go into too much detail. Of course, the slides will be shared afterwards, and if there's anything else you would like to know, please let me know. Drop me an email. In terms of crypto assets, in order to issue crypto assets and provide them to the public, you will need to draft a white paper, and you will also need to publish it on your website. You will need to notify this white paper to the competent authority. However, they do not need to approve it on beforehand. They only need to be notified. You need to be a legal entity in order to offer crypto assets or seek admission to trading thereof. Then there are a couple of specific rules in terms of liability and in terms of marketing, and of course also a right of withdrawal for 14 days for EU customers, which, well, we already had under EU consumer law anyway. Asset reference tokens, however, are regulated quite a bit more strict. In order to provide asset reference tokens to the public, you need to have a prior authorization. Luckily, this is an EU-wide license, which means that if you're established in one member state, you can get a license in that one member state and then use that license all across the EU. So it's just that one license, the entire EU opens up for you, which is, of course, a great step forward compared to what we have now under the Anti-Money Laundering Directive, where you need to go to every different member state. Also here, a white paper needs to be produced and published, but there are quite a bit of limitations to issuing asset reference tokens. For instance, you're limited to having a quarterly average of only 1 million transactions or total value in transactions of 200 million. That is not quite a lot. There are already quite a few stable coins today that are going way above that. So that's definitely quite a bit of a restriction that I'm afraid might really start hampering the practical use of stable coins. In terms of rules then, quite a bit of prudential and conduct of business rules. You need to have all kinds of policies in place, for instance, for complaints handling, internal governance, security policies, and all of that. They must also maintain a reserve of assets. It means that the asset reference tokens that you're issuing must be, at least for a certain part, asset-backed. And that is, of course, something that today in practice, there are quite a few stable coins that are not asset-backed or at least not fully asset-backed. So that is something that will need to change here in Europe. Customers have a right to redemption, prohibition of granting interest. It will be interesting to see what this means for staking. Today, if you stake your coins at a service provider, they will very often provide you with a share of the proceedings that they derive from staking in the form of an annual yield. Strictly speaking, that is granting interest, so that's technically prohibited under this framework. So we'll have to see how that develops in practice. Now, in principle, these issuers of tokens are regulated nationally with a competent authority of their home member state. However, if you become so big that you pass a certain threshold and that I list here, then you will become listed as a significant asset reference token issuer, and then you're placed under European supervision. And that also comes with a bit tighter rules, of course. Then for the last type of token, the e-money tokens, well, those are actually a little bit easier. Those are just considered as e-money. We already have a legal framework in Europe on e-money since 2000, so for quite a while already. So if you want to issue e-money tokens, you will simply need to get a license as an EMI, an e-money institution, and then you're allowed to do it. You will also still need to publish a white paper. Which actually gives us a bit of an interesting duality now. E-money tokens are regulated in the same way as e-money already was regulated in the EU. However, because these e-money tokens are issued on the blockchain rather than using a different kind of technology, they're regulated a bit more strictly because you also have that white paper obligation. So there are now two classes of e-money, which is a bit of a strange development. Also here, you can have significant e-money tokens, the ones that grow a little bit too big for the European Union's risk appetite. Also, they are placed under EU supervision and are subject to some stricter rules. Now, for the service providers, a little bit of the same ideas for asset reference tokens, in fact. Also, they are subject to an authorization requirement, which means you need to get a European license. Unless you do reverse solicitation, that is allowed, but only when it's really with a passive involvement. Also here, prudential and conduct of business rules, all kinds of policies that are required, specific rules for outsourcing, if you're relying on the services of others, you need to avoid certain risks, have an exit strategy in place, and on these type of things. And then there are also a couple of specific rules depending on the type of service. For instance, if you provide custody of crypto assets, there are a couple of requirements that need to be present in the agreement that you have with your client. You need to have a policy on internal access. You need to hold a register of the positions of your clients, etc. For trading platforms, this mainly concerns operating rules and due diligence, a prohibition for trading on your own platform, some rules on operational resilience, and having a backup plan. And also here, significant service providers, the ones with more than 50 million active users, must be notified, but here they're not immediately placed under a stricter regime yet. They only need to be notified. And then more generally, there are also still rules on market abuse, like on the disclosure of inside information, insider dealing, prohibition of market manipulation and market abuse. In terms of supervision, of course, the national authorities and also the European authorities, like the European Banking Authority and the European Securities and Markets Authority, they get all kinds of specific powers in order to really enforce this framework. Also very important in practice, or that will be administered sanctions in case of non-compliance with this framework. Fines can go up to 5 million euro or 12.5% of the annual turnover, depending on the type of infringement. But in cases of market abuse, it can even go up to 15 million euro or 15% of the annual turnover. So those are quite some hefty fines, which is definitely something that you'll want to avoid happening to you. Now, even though MiCAR is a very broad framework, there are also a couple of things that are not included. First of all, central bank digital currencies. So if a central bank would issue its own digital currency, as the European Central Bank is currently contemplating with the digital euro project that they're working on, they are not caught under the scope of this framework. Secondly, NFTs are not under the scope of MiCAR, but only insofar as they are really non-fungible. What happens in practice is that you often have these NFT collections where you have 1,000 NFTs that are all referring to the same kind of asset. Technically, they're unique, as every NFT is a unique token on the blockchain, but they all convey the same rights on the holder. In that case, they're not really unique and they may be put on the place of MiCAR. So you really need to have a case of one token, one right, completely different from the other token and the other rights that those tokens are conveying. Utility tokens also do not fall under the scope of the framework, but only when they are used for certain goods or services where the good already exists or the service is in operation. So these can be tokens that, for instance, you can use in a video game as certain assets, but they're only exempted from the scope of this framework in case the utility is real. And that's also, of course, also something that we very often see in practice, that people promise it's going to be a utility token, that the utility is promised, but it's never really realized in practice. So that is something that is considered here. And then closing off, also not included are security tokens, because security tokens can be considered as financial instruments under the MiFID II directive, which is the main EU securities law framework. So if a token is an instrument, it has an identifiable issuer and it grants certain rights on the holder. These can be financial rights like share in the profits or a right to payment, or it can be participation rights like voting rights. Then it can really be considered as a security, and then it's regulated under MiFID II and not under MiCAR. It can also go a little bit broader than a security in se. For instance, if the token has a right to delivery of a good or a service that has certain investment characteristics, then it could still be considered as an investment instrument. That doesn't fall under the scope of securities law, but it also does trigger the prospectus duty. So if you would like to issue a token that could be considered as an investment instrument, then you would need to publish a prospectus, but it would not fall under the scope of MiCAR. And that is, in a nutshell, all I had to say. As I mentioned, in the interest of time, I had to go a little bit quick over certain things. So if anyone would like more details on that, feel free to contact me. Thank you.
Thank you very much, Niels. It was a very interesting presentation, and our participants can still ask questions in the Q&A if they would like more clarification. But I already see a question there. So one of our participants asks if regulatory authorities are in a way not doomed to constantly lag behind new technology developments and innovations, and what can be done to avoid this situation. And perhaps starting with you, John, since you touched upon this throughout your presentation, what are your thoughts on sort of the proactive path to this?
Yeah, and I can just speak from my experience in the United States that there is always a lag. And I think that the legislative process is especially vulnerable to that. I don't think the quagmire in the US Congress is any secret. To some extent, that also applies on the state level. But you have seen some states like Wyoming and other states really take the lead on developing innovative ways to regulate in this space and attract new business. And I also think that that's why there's a especially important role for regulators, the folks that enforce the laws already on the books. They have, in many cases, the discretion to provide a stopgap while the legislative process plays out. And, you know, for example, in Washington State, the Department of Financial Institutions has developed a program, a sandbox type program on its own, without legislative guidance. So those are the types of things that I think can kind of mitigate that problem. But yes, the answer to the question is, I think it's just the nature of things that the legislative process always lags, but behind technology.
And Niels, with this new
Yeah, I
regulation now
mean,
approves, are we in Europe less lagging behind or still
well,
lagging?
to give an idea, I think it was in 2015 that it was first mentioned that we needed a comprehensive framework. It was in 2020 that the first proposal of MiCAR was published, and it would still take until today, 2023, before it was adopted. So it's been a while. And yeah, of course, since the proposal was published, a lot of things have happened, which already has led, for instance, the European Central Bank to call for a MiCAR 2 regulation, even before MiCAR 1 was adopted, because they already knew that, okay, this is a good text, but there has already been developments that are not included here. So we need to continue moving. In a way, that's always going to happen, of course, with technology that's moving this fast. I think the idea is just to have the general framework, and then trying to fill in the gaps as you go, for instance, by means of implementing acts and things like that that can be adopted on a shorter notice than a big framework like a regulation itself. And indeed, as Sean mentioned, I think giving also some work to the regulators themselves, because they're the ones looking at the field and having all the context there and knowing what's going on, and they can help provide guidance. Sometimes we don't need new laws for every little thing that changes. Sometimes it's just, okay, we have these laws, but we just need to look at the interpretation of them.
And also on the markets in crypto assets regulation, Niels, we have a question on whether now that it's approved, can it affect the relations between EU and US holders of digital assets, and if there are any legal implications for already ongoing digital businesses in Europe and in the US?
I think the interesting thing that we're going to see now is that certain crypto are going to be considered in a very different way. For instance, if crypto can be considered as a security, obviously there are differences between EU and US securities law, but the idea is the same. It's a security. You can't just put securities on the market like that. You can't become a securities broker like that. There are rules for things like that. So even though the rules are different, the philosophy behind them is a little bit the same. But what we're having now is that Europe is considering some of them as crypto assets under this framework, while in the US there's more the tendency of saying, oh no, those are securities. And I think that's going to be a little bit tricky for companies to try and accommodate this, having one asset being considered in these widely different ways. And then, of course, yeah, some of the limitations, I'm wondering how those are going to be enforced in practice. For instance, like I said, with asset reference tokens, the thresholds that you have there, you can easily reach those in the US alone. So how are you going to differentiate between the US and Europe? I think this might lead to a bit of market segregation, but we'll have to see how that develops.
Yes, since it's only been approved today, we can of course have to be careful with looking at the future. But we have a question that looks more at the present, and that is addressed to the both of you, in the sense of what has so far been the response from the crypto industry, crypto companies to all of these policy developments in Europe and in the US. Have more stringent regulations been welcomed, criticized, and whether we can expect a race to the bottom to ensue? Perhaps starting with you, John.
It's a good question. I think that, well, let me take a step back and come from the US perspective. I think what you saw early on in a state like New York, which adopted the BIT license, which applied, as I mentioned, many of the same type of regulations that had been applied to banks and other financial institutions for years. And obviously that was subject to heavy criticism at the time. Kraken left and others left. And I think the critique is that, at least at that time, was those types of regulations really benefit incumbents. So existing players in the financial markets and the securities spaces. And so I think on balance, and again, it's all about striking the right balance, but on balance, if you're a new company, the fewer the regulations, the better, because that just means if there are more regulations, you have to spend more money complying. And things are tight for most startups, at least for the beginning phases. But you have not seen a quote unquote race to the bottom, at least at the state level. You've really seen a range of different approaches, a very cautious approach, and also kind of New York being on one end of the spectrum of being heavily regulated, at least from the perspective of the industry, and then Wyoming being heavily digital asset favorable, and then a number of different approaches in between.
Yeah, I think from our perspective, as I mentioned, the single EU license that MiCAR provides is definitely a huge step forward. Right now, the process that you have to go to every single member state and try to comply is an absolute mess and an expensive mess. Binance was banned in Italy for a while. Coinbase was fined in the Netherlands because, you know, they were trying to get their compliance in order, but with 27 different member states, it gets difficult. So the idea of having this single license, okay, I'm going to go to one member state, I'm going to get my compliance sorted there, and I'm compliant for the entire EU bloc, I think that's going to be a huge step forward.
And Niels, in your presentation, you touched upon the environmental impact of cryptocurrencies, and the MiCA regulation does include some provisions in this regard. Are they likely to have any impact in terms of mitigating the environmental impact of cryptocurrencies?
Today, I don't think so. It's kind of been toned down. There was at a certain point a proposal coming from the European Parliament to outright ban proof of work crypto like Bitcoin. That was toned down to the extent that they will need to consider the environmental impact. They will need to warn their customers about the environmental impact. And they will also need to report that to the European Commission so that they can evaluate it and maybe take steps later. So today, I don't think it's going to have a big impact just yet, but I do think it's a bit of a wake-up call to entities in the sphere to really start considering that. And especially in the case of Bitcoin, I really think that the proof of work consensus mechanism is going to have to go somewhere in the next coming years, probably.
And what about in the US, John? Are there regulatory initiatives, either at federal or state level, that also aim to mitigate the environmental impact of cryptocurrencies, or has so far this topic stayed out of regulatory efforts?
Yeah, no, I mean, it is an important issue, and I think you see it, especially in the crypto mining area, right? And that especially in Washington State, that has, typically been a pro-environment state. That's definitely been a factor that lawmakers are weighing. And having said that, I think Niels is right on that there are creative ways that can make I'll say, components of the broader digital asset industry more environmentally friendly to kind of satisfy that element, which is important, right? I wouldn't go as far to say that it's a black eye on the industry, but it's definitely a optics issue in terms of moving forward with industry-friendly regulation.
I also wanted to take the opportunity to ask about data protection, since you've also touched upon the topic in your presentations, and as well as because 2 years ago now, the European Data Protection Supervisor, when it analyzed the MiCA proposal, it stressed that there was a need for broader reflection and discussion on whether the technology underlining crypto assets respects data protection rules and principles. So Niels, what is the state of this discussion now in Europe? And then John, are there similar discussions taking place in the US with regards to data protection?
Yeah, I think the general approach of MiCA is just to reference GDPR and stating that, well, all data processing needs to be in line with GDPR, which is, of course, a given. We didn't even need that reference. So there's not much development there. In terms of general blockchain use, yeah, of course, it's important to develop that in a way that is compliant with GDPR. And yeah, obviously, the sensible thing is do not put personal data on the blockchain itself if it cannot be amended or removed. That should go without saying, but unfortunately, there's still quite a lot of educating and development to be done in that field.
You, John?
Yeah, so I think there has been some conversation around this topic, and just relating back to a previous question I saw about, what does that mean for compliance in the US and compliance in the EU? And obviously, the EU and Europe have much, I would say, more robust privacy laws than the US. And I don't know if that's a social or cultural phenomenon or what. So while there has been discussion around that topic, it has not been a hot topic, at least in the space that I work in.
Mm-hmm. And we are almost at the end of our webinar, so I'll perhaps end with a provocative question, if you allow me. But we've discussed quite a lot of regulatory initiatives in the EU and the US, some more fragmented than others, but still quite a lot going on in this field. Is this enough to prevent another shock to the crypto world to occur? Are these initiatives sufficient to prevent that another scandal like the FTX collapse happens again, or is this still a possibility that is not addressed to date? And perhaps starting with Niels, since your EU is more advanced in regulation in this field.
Well, can we say with certainty that's never going to happen? No, of course not. I mean, if you look at banks, banking regulation has been quite strict in Europe for quite a while, and then we had the 2008 crisis. We made the banking regulation even more strict, and even today they're getting a little bit concerned about what's going on all over the world. So it doesn't look like banks are going to collapse in Europe, but hey, who knows? It could happen. And I think the same thing here. If you look at FTX and some of the other collapses that have happened, even a recent one here in Belgium, there are definitely elements in those files that could have been addressed by MiCA. But of course, that's no guarantee that, there isn't going to be a bad actor or that somebody manages to keep it hidden from the regulators. So it's always going to be it's going to weed out some of the bad apples, but not all of them, probably.
Your final thoughts, John?
Yeah, I'll agree, and choose my words carefully, like Niels did. No, I'm just kidding. I do think, going back to my general thesis, that you're never going to entirely root out all misconduct, right? And I don't think that should be the goal, because you risk, depressing or inhibiting innovation. I think there's a balance that can be struck, and ultimately, you know, that's going to take time to play out, whether it's in the EU with its new initiatives, or it's definitely going to take time in the US to play out. I'll say that currently what we're seeing in the US to try and prevent another calamity like FTX is the SEC is taking painting with a very broad brush in terms of its enforcement activity. But again, that approach, some might say, is short-sighted, because what that lacks is a kind of clear, predictable framework of rules that everyone can agree to operate within.
Well, thank you both very much. These were all very interesting perspectives, but unfortunately that is all the time that we have for today. So thank you as well to our audience for taking part in the webinar and asking very interesting questions. If you'd like to know more about the America Europe Fund, our upcoming events, or watch recordings of past events, including this one, you can do so on our website, which is america-europefund.eu. So thank you very much for joining us today, and have a good evening.
Thank you. Bye.
Yes, thank you very much. I assume we're not